friends, Namaskaram, how are you? Myself is Dr. Soni. I am an advocate. In today's class, I will discuss about revision, its scope and limitation. I will discuss this topic more specifically in light of criminal litigations. As far as revision is concerned, the scope of which is quite limited. The court has to find out the error of law. If there is no error of law in that scenario, the revision would not lie. These are not my words. I am submitting the said words from the guidelines that is propounded by Honorable Supreme Court in its one of the most important judgment. The citation is 2022 Volume 8, SCC page 2024. In that case, it is observed by Honorable Apex Court that the scope of revision is limited. The court has to find out the error of law. So if there is no error of law, the revision petition would not lie. Apart from that, I am going to cite one of the most important judgment of Honorable Supreme Court, that is 2002 Criminal Law Reporter, page number 101. In that case, the court specified that the order must be impugned, perverse, and against the law. If there is nothing on record to suggest that it is against the law, in that scenario, the petition of revision would not lie. So basically, we have to emphasize on error of law, not on the factual controversy. It is to be noted that every order is not revisable. We have to specify that the order inter alia falls within the category of intermediary order. If the order is interlocutory, in that scenario, we could not be succeeded. Now the important question arises how to differentiate how the order is interlocutory and how the order is intermediary. We could simply take a general test. If the concerned order is inter alia concerned with the process of the court, it is called the interlocutory order. For example, you file an application before the concerned court to summon any file, and court reject your plea. In that scenario, it is concerned with the process. It is not going to affect your rights. It is not going to impose any liability on you. So in that scenario, no revision petition would lie. So concerning that order, either we may proceed before Honorable High Court as per section 5 to 8 of BNSS, or we could wait till the maturity of the stage. For example, if court says that wait for the due date or come on due date, then on due date again we could move the application. But as far as the intermediary order is concerned, it might affect our rights, it might impose liability, it might compress our existing rights. In that scenario, we have to file the revision. But still, while filing the revision, we have to understand the key performance indicator, that is error of law. So if in your petition there is no error of law, you could not be succeeded. For example, you are contesting a check case. You are the complainant and inter alia you failed to appear. And the concerned court dismiss your complaint. So what you could plead before the court of revision? That the order is passed in the mechanical way. Because as per the guidelines, the order could not be passed in the mechanical way. First, the court has to ascertain where is the complainant. The court has to issue the show cause notice, and despite of all the efforts, the complainant failed to appear. In that scenario, the dismissal is justified. But in our case, no such efforts has been done by the concerned trial court. So basically, it is error of law because the law says no order could be passed in the mechanical way. And apart from that, while dismissing the complaint, the court must not be in the anxiety. So if both the criteria are violated, in that scenario, the order is revisable and apparently the error of law is evident. So in that scenario, we could be succeeded to file a revision petition. So I think that I specify you the scope of revision along with the limitation. We must keep in our mind two important key performance indicators. Number one, there should not be any factual controversy. Number two, we have to specify the error of law. Means we have to specify that the order pronounced by the concerned magistrate is against the settled legal position. And if we totally failed to specify the set criteria, in that scenario, we could not be succeeded and our revision petition would be dismissed at all. So I specify you in which manner the revision petition is to be drafted, what will be the key performance indicator, what will be the scope, and what will be the limitation. See you in the next video. Till then, Jai Hind, Jai Bharat.